Great. My name is Christopher King. I work at a law firm here in town, Callahan King. It's myself, my partner Robert Callahan, and 3 other attorneys and 5, I think maybe 6 now, support staff of different levels, paralegals and receptionists, that kind of stuff. Our law firm does maybe about 50% criminal law, 30–40% family law that has to do with custody disputes and divorces and adoptions and stuff like that, and then 10–20% of just a lot of other stuff, property, and we used to do immigration. I guess we don't anymore, some other random things. I do 90% or so criminal defense, and maybe one of the biggest misconceptions that y'all might have already been told about. I don't know. Actually, I'm just going to jump into 2 big things about my profession being a criminal defense attorney that most people don't know about. One, in movies and TV shows, before I became a lawyer, all I ever knew was you have a public defender's office, and then you might go and hire an attorney. And that is a thing that exists out there, but in Texas, most of the public defended cases are actually a private attorney. So most attorneys that practice criminal defense, the county, the court system appoints us to a case to handle a case for somebody that can't afford to hire a lawyer. So the majority of my cases, maybe about 60, reaching into 70%, are court-appointed cases where they're not paying us. At the end of the case, the judge will approve us to be paid by the county.
So is there not a whole lot of public defenders that are like a public defender's office in Texas, or is that limited to like major cities?
On the state side, there's maybe 3 or 4 across Texas, and they're in the major cities mostly. On the federal side, there are more public defenders, and that's a totally separate system. State side, federal side, different courthouses, different judges, different prosecutors, different law. And on the federal side, there's more public defenders. The second and maybe biggest misconception is, especially at root, when people are asking or thinking to themselves, how can you defend guilty people? 95+% of what I do has nothing to do with, is this person guilty or are they not guilty? We're, of course, as the attorneys, we're looking to see, is that actually there? Is that the case, that there is enough evidence that they either, I know they're guilty, or like a case that I had set for trial on Monday, was able to explain to the client, all the evidence sure makes it look like you're guilty. So in the vast majority of the time, I am arguing with a prosecutor or a judge or a jury, what's the proper sentence? What is a just sentence? Is it 20 years in prison, or is it 5 years in prison? Is it probation? Is it something that's going to keep it off the record so that they can go to college or go to the military or what have you? So that's probably 2 of the biggest misconceptions, and then I think that I've answered a couple of y'all's questions just about my general background. Just jump into questions then?
Yeah,
okay.
Guys, you can look at the questions. If anyone has a question at any point, just raise your hand, and remember guys, it's a pretty much open forum. It's Ask Me Anything, so.
I love interactions, so feel free to jump in the middle of something I'm explaining. Okay, so you who are wanting to steal the mammoth skeleton bones, you would get a couple of years in federal prison. And maybe one big thing, y'all probably don't read the news stories where they're saying this, a sex offender is going to prison for 40 years, and then somebody in a different situation where they maybe had a pretty crazy, this isn't maybe as crazy as being a sex offender, situation is going to prison, and it's like a 2-year prison sentence. So like I said, state and federal, very different systems. On the state side, if you have a prison sentence, you can get parole. So if you're doing the right things in prison, especially if you're showing rehabilitation, I maybe even murdered someone. 30 years of being in prison, if you've had a clean record that whole time, they may actually let you out on parole. Maybe even earlier than that in a situation that's not murder. A federal sentence, though, you're going to serve 85% or more of that sentence. So if it's a 2-year sentence, you're going to be in there for probably 2 years. And when you get out, there's extra, it's almost like probation, that if you mess that up again, you'll go back to prison. So when I say that you might serve a couple of years in federal prison, that's a pretty stiff sentence. You probably don't want that. You'll come out a completely different person than you are now. So I would recommend not doing it.
Okay,
That's
so
my
to kind of go
advice
along
to
with
you.
that, guys, so Mr. King, what would be some differences between a federal crime versus a state crime? What would be an automatic federal crime no matter what?
Any crime committed on federal land. So I defend cases that are on Fort Hood because that's federal land.
Yeah.
And then in any other situation where the crime was committed not on federal land, it's just, there's not that much land that's federal. There's DC and their bases and
Indian reservations.
Indian reservations, yeah. Although they have there's kind of a different thing that can happen there too. But then if it's a crime not committed on federal land, so the vast majority of the United States, they can federalize the case. So I have, I think, 3 or 4 clients right now, and they have state charges and they have federal charges. And those may have come out of the exact same arrest. But there was something about the case that the federal government decided to prosecute that they really wanted to have that case. Whether it was, and the federal government, they typically deal with drugs, high levels, guns, and immigration. Those are the 3, probably 90% of federal cases are those 3 things. Immigration is specifically a federal offense, so that's always, every immigration case, reentry case, is going to be on the federal side. But then if it's guns, they're always trying to stop the traffic of guns in and among the states, and the majority of those cases are possession of a firearm by a felon. If you have a felony conviction, you don't have the right to own or possess a firearm. That's a state charge, it can also be a federal charge. So they can choose either state or federal. Technically, they can do both. That really sucks.
Is that not double jeopardy?
It's not.
Why is that not double jeopardy?
Because of the dual sovereign doctrine. So you have the state government and the federal government, and you can act like they're almost 2 different countries.
Wow.
So you can be prosecuted for the same charge federally as you were state-wise. However, after, I think, the Rodney King situation, there was a situation maybe in the 80s where it is now the policy, so the law allows you to do that.
Yeah.
But it's the policy of the Attorney General of the United States not to prosecute a crime on the federal side that has already been prosecuted to completion on the state side. There's not a similar policy on the state side for that.
Okay.
So we've even had a situation, I had a client, Charles Scott, 5 years ago. He was in our jail, local jail, and he was being prosecuted federally. They brought him over to the feds, finished his situation, and he was sentenced to 15 years federal time, which, like I said, that means you're going to do pretty much all that 15 years. And the state prosecutors back then, under a different DA, they did not want to let go of our state case. We had told them, hey, he's been prosecuted, he's got a sentence, he's not yours to worry about. And in his situation, it actually would have been mandatory that he would serve that 15-year sentence, and then any sentence he got from the state prosecutors would be served in addition to that. It's called a stacked sentence, as opposed to a concurrent sentence, which means they run at the same time. And
what can you share with us? What kind of crime got them so up in arms that they want to do that?
his was drugs. So they arrested him. It was the exact same arrest. It wasn't even like he's a drug dealer and had drugs this situation. They arrested him, so he didn't have the drugs, but he bonded out, and then he had more drugs.
Wow.
It was the exact same. They got him. He had some mental health issues, claimed that it was his personal use, and I don't really know which it was.
Okay. All right, so let's theoretically speaking, let's say I decide to start my own business selling controlled substances through the U.S. mail.
Mm-hmm.
Would that be a federal or a state charge as I'm shipping my high quality product of whatever it is to, say, other people in the state of Texas?
Almost always going to be federal. So anytime that you're using some apparatus in the federal government, like the mail system, or anytime that you're crossing state borders to commit your crimes, no matter what the crime is at that point, it can and usually will be a federal case.
Yeah.
But they could, for instance, if you're using the postal system, but then state agency officers come to your house, they don't know or care about you using the postal system, and they just see that you have drugs in the house, then they may even arrest you on the state side, and then
Then the federal
state
come in
side
also.
Yeah.
Okay.
And I mentioned before you can parole out on state sentences. So if you have a 40-year sentence, you may not actually serve 40 years. There are pros and cons on either way. So to be honest, sometimes I prefer that my clients would have a federal charge. Sometimes I prefer that they have a state charge. I don't get to choose. They don't ask for my advice on it.
They just do what they want.
Yeah, they do, very much. Is there a court case where both sides lost? So a little bit, as little as I can make it, of what I do is family law, is child custody disputes and sometimes property disputes between married or formerly married people. The only way that you can know that the judge probably made the right decision is if both sides feel like they lost. And I had a hearing last week and was commiserating with my coworkers at the time. I think the only way that you can really figure out, because you're always going to feel like you lost, the only way that you can figure out if you did well is if you think, well, if I'm the other side, am I going to feel worse about this than I feel about this right now? Because you're just going to feel bad about it no matter what. So,
And that's mostly in like family law cases.
Right.
So not so much prison sentence, not so much criminal cases, but more family law.
Right, but that is one aspect of defending criminal cases is you have to redefine what winning is sometimes.
Yeah.
And that's, you have to have a proper understanding of what it's going to be. So to me, sometimes winning is just getting my client to see at least a vague version of reality for what it is.
Yeah.
Because so many of the people that I work for or work with, they're just kind of off in la la land. It doesn't seem like they understand what's going on. But then sometimes you'll take a case to trial, not because you're there to prove that they didn't do it, but because the offer was 30 years and you think that you should be able to get a 10-year sentence because that's what a jury would normally give in a situation like that. So that's a win if you come in and you get a 10-year sentence. Your client's guilty, they're going to prison, but that may be exactly what they maybe even wanted, and it's probably, in that situation, it's probably the just result if you can get 12 people in a jury to agree that that's what they should do.
Let's take a couple questions real quick. All right, so who's got a question? You want a legal question answered? You're like not sure why someone went to prison. Who's got a question right now? Are all y'all asleep still this morning? Okay. All right. Do you
Here's
want go ahead.
Yeah, how long does it take for a case to go to trial? So there's this thing called a pandemic going on right now. And I guess is in some varying level of a downward turn, but we have probably had 12 trials in the last 2.5 years in our county. So you might imagine, I had a case, like I said, it was set for trial a couple of days from now in Bell County, and they've had maybe 5 trials in the last 2.5 years. That case was from conduct that alleged to have occurred in 2017. And it's a misdemeanor case. It's not, going to prison for 20 years kind of thing. So we're in weird territory right now because of the pandemic. That stopped most jury trials from being able to happen because you can't get 60 people in a room when you have a pandemic going on, at least not very easily. So if we take that out of the equation though, most cases from arrest to when you actually have a trial and the jury is getting to see the case, if it's a misdemeanor, it's going to be at least a year. So if it's the kind of case that you might go to jail, but there's a good chance you'll even just do probation, it's going to be at least a year usually before you can get to trial. If it's a felony case, and if it's a felony case that's not a sex case, not a sexual assault case of some kind, then it's going to be usually at least 2 years. If it's a sex case, usually it's 3 to 4, something like that.
Why the longer lead time for the more violent cases?
They take longer, there are more of them, they're less likely to plead. So if I have a client and, for instance, the case that was set for trial this next Monday, the alternative to going to trial is he's going to be on probation. If you can say, well, I'll do probation, that's much easier to stomach, even if you believe that you're innocent of the case. That's much easier to stomach to do probation than, well, I know I'm innocent, but you're telling me I would have to go to prison for 10 years. That's a difficult decision to make. If you believe you're innocent, you know you're innocent. There are lots of cases that should have a trial, but they don't have a trial. I mean, there's plenty of cases that I believe my client is innocent of what they're charged with, but my advice to them is still hedge your bets instead of going to trial, because it's a risk no matter what. It's 6 in a misdemeanor case or 12 jurors in a felony case. There's just random people picked off the street, basically. You don't know who they're going to be. Instead of taking the risk of a trial, even though I think you're innocent, it's actually the safer version, the safer choice to take whatever plea offer we have, and that's a much easier calculation to make if it's probation or a Class C ticket, a traffic ticket type thing, where you just have to pay a fine kind of offer. So it's a lot more likely for felony cases to go to trial because the alternative is usually a lot harder to stomach.
So if let's say, and I'm just going to theoretically here, let's say I, not paying attention while I'm driving, I hit somebody with my car and I end up killing them. I stop, I render aid.
You're drinking, I assume?
No. Looking for a song on Spotify.
Okay.
Okay, which I think is much. Oh wow, I got a rise out of y'all. Okay, looking for a song on Spotify, accidentally hit somebody, accidentally kill them, I stop, I render aid. What kind of charge would I might be placed with?
So the facts that you just laid out should not result in any charge for you.
Okay.
And then I can modify those facts a little bit to show where the charges could be if you want. So the law has this concept called a reasonable person. And we use that in situations where there's like no other way to really explain. It's kind of like our gap filler. What would a reasonable person do in this situation? Well, that's what you should have done. So if the decision maker, and I'll just leave that as vague because it can be lots of different people along the way, believes that you were acting reasonably, then you did everything you should. You accident, no criminal liability, hit someone. You shouldn't have, but none of us should do things that causes others injury.
Yeah.
But the way that you laid it out, it sounds like it can be, most cops are going to say that it's a pure accident. And you stopped and rendered aid like you're supposed to. So you accidentally hit someone, you're not criminally culpable, you're not responsible for it. But then if you keep driving on, you've now committed a felony. Failure to stop and render aid with serious bodily injury.
So I've hit somebody, and instead of stopping to render aid, all I'm doing is I'm freaking out. I'm like, okay, and I start speeding off.
Right.
Now, that's where I've moved into, I'm now committing a felony.
You've now described one of my cases from a couple of years ago.
Okay.
He started freaking out. He went not far, more than a couple blocks, less than a mile, and called his dad immediately. And I forget if he couldn't get to his dad or his dad gave him bad advice, but he didn't immediately go back and do the thing. The person wasn't dying, but they were injured. I think it was the next day he reached out and then eventually got connected with police officers who were friendly and came and arrested him.
Yeah.
And he was a young guy, not too much older than y'all are. And they filed failure to stop and render aid. They considered some sort of aggravated assault with a deadly weapon, the deadly weapon being your vehicle. A deadly weapon could be anything that can cause death, and vehicles cause death quite a lot. So they had a second-degree felony charge. You go to prison for up to 20 years, and then they had this failure to stop and render aid felony, which is a hybrid, but basically you can go to prison for up to 5 years. And with those facts, pretty similar to what you just gave, you're responsible, but then, like I said, the main argument is what's the right punishment? What should happen? So in his situation, because he was young, he had asked for advice, and he did make contact with the cops afterwards, even though it wasn't when he should have, to stop and make sure the person's okay and call an ambulance and all that kind of stuff. They agreed to do what's called pretrial intervention, which means basically you keep it off your record. That's the most important part. Being young, you don't want a criminal charge off your record. Criminal charges will never leave your record. Once on there, it's on there for your entire life.
So I've heard of something, and this may just be an entire movie thing or TV thing. I heard that you can get your record expunged. Is that actually a real thing?
Okay, so my goal here is to try to explain things in an approachable way that
there's no approachable way for that question, is there?
But I have that conversation with my clients probably at least once a week.
Wow.
And if I have to explain it to them, y'all get the explanation also. Okay, so a criminal conviction will always be on your record. There are ways to avoid a criminal conviction even if you're pleading guilty. The primary way is through deferred probation. So we have two things, we'll say three things we're talking about. Best is if you're arrested, you don't beat the ride, but it's dismissed. You do beat the rap. So a case that's dismissed, you still have that arrest on your record. So you're applying to HEB and they can see, oh, looks like you've been arrested for this thing. What happened there? Well, if it's dismissed, they should be smart enough to know you were wrongfully arrested. That's what that essentially means. But if you have a mom and pop employer who's looking to see what your criminal record looks like, they may not know that if you're arrested and then the case is dismissed, that means you didn't do it. They may hold that against you and then that kind of stinks. So you have an arrest, but a dismissal. You have deferred probation, which is one step better, or you have a conviction. A conviction will stay on your record your entire life. It cannot be expunged in any form whatsoever, not any, none, never gonna happen.
Okay.
Under current law, so who knows what happens in the future. But I don't think that's probably ever gonna happen. With deferred probation, you can get an order of non-disclosure, which means that there is a lid that is put on that record so that most people can't see the record. Now, government agencies, certainly the military, banks, nursing and teaching industries and some related, like the Board of Nursing and things like that, they can still see that record. But everybody else, there's a lid on it. It's as if it never happened. So that's kind of good. But then in that first situation, if you have an arrest, but then it's dismissed, you can get an expunction.
Okay.
Which doesn't put a cap on that record, it obliterates it. It is as if that arrest never happened. Legally, you were never arrested. And when you go to apply for a job or some kind of schooling or an apartment, on the application, it's typically, the top part is like identifying information. Usually the very first question after that is, have you ever been arrested for anything above a Class C misdemeanor offense? Or have you ever been convicted? It will sometimes ask. You get to say, no, I haven't ever been arrested or convicted. I wasn't arrested. You can go look at my criminal record. There's not an arrest on that record. So if it's expunged, it's destroyed. You get a notification from the clerk after we file an expunction, which is a difficult technical thing to have to do, that tells us afterwards, hey, on such and such date, your record was, and they literally use the word obliterated. Your record does not exist. No state agency or anything knows that it happened because they've gone in their record database and deleted that also.
Nice.
As long as it's done properly. Now, I had a client, and okay, well, this goes into, somebody asked, I think maybe two different questions. What was the, have you ever had a quick and easy case? All right, so I'm gonna give you two examples, and I'm gonna start with the easiest case I've ever had. There's a man named Ebiotibos Salimabri, who was stopped in Mart on the way to Austin, I think. He was an MIT grad working on his PhD at the University of Louisiana. You might imagine he wasn't from the United States. Ebiotibos Salimabri.
Don't try to spell that, guys.
And I had to.
Yeah, I know you did.
Because where this is going. He was a dark-skinned man stopped in Mart, and they believe that he had prescription medications illegally. They stopped him for a pretextual reason. Basically, he committed a traffic violation that's not the kind of thing that matters. It's not like speeding. I think it was a wide right turn, which is where, that's left, this is right, where you turn and you cross the line when you turn in. And so they stopped him and they profiled him and they found medications that he could not communicate to them that he had prescriptions for, okay? I was appointed in the morning at about 11 a.m. I met with him because he wanted to meet with me right away because he was from out of town. And then by 1 o'clock, I had his prescription in hand and was able to walk to the DA's office and get the case dismissed because it was so obvious that they had profiled him and he had the prescription and there's no reason to charge him with a crime. So that was one of the easiest cases I've ever had. Submitted the requisition that afternoon and got paid a couple weeks later. But Ebiotibos Salimabri had an arrest on his record and later hired us for an expunction. We got an expunction, which obliterates that arrest from his record so that he can continue to be a PhD grad and go and do who knows what amazing things now. Last I checked, which was probably a year ago, but probably still to this day, even though his arrest has been expunged, if you search his name on Google, you better believe there's not another Celebrity, and there's some random website from that has a domain registration from out of the United States, so I can't file a lawsuit against them saying you're committing libel against my client, who has his arrest record still on there. It's just a random website that just collects arrest records, puts them online, and then doesn't check their work so that they actually know that it was a proper arrest.
Yeah.
So in some situations, you may even get an expunction and it's not everything that you want or need. I had a client who's a master's, she's still around, so I don't feel comfortable saying her name, but
yeah.
Master's student at Baylor who got an expunction for after a mental health related incident caused her to have an assault, family violence arrest. And she asked us just this week, hey, can you check my criminal background? Because I don't know if it's cycled through yet, and I'm applying to PhD programs now, and I don't want it to be on, I don't want it to have to be something that I explain to them, because you want it to just be gone if you didn't actually do it. So that's good scenario, best or quickest case I've ever had. Maybe a less good scenario, quickest case that we've ever had. We have a client right now who's in jail on his, we handled his 26th criminal trespass case. Criminal trespass, if I see someone with more than one, and especially if they have many, that means you have pretty significant mental health issues. You're probably homeless, and you might not even care. Very rare situation, you might not even care if you are in jail. You might be looking to get into jail.
So what is criminal trespass?
Being where you're not supposed to be.
And someone asks you to leave?
Yeah, so specifically knowing that you can't be there. So that usually comes in with somebody tells you, hey, get out. They tell you get out, you leave, you come back the next day, well, you know you're not supposed to be there. So you're criminally trespassing there. Or I tell you, you need to get out, and it's my property, and you don't get out. You refuse, and it's been, the police are called out, and they tell you to get out and leave, and you're still not leaving. You're now criminally trespassing. So he's on property that he's not supposed to be on 26 times, and we had that case maybe 3 months ago, and he was in jail for a while, told us he didn't mind it a whole lot, but then we have court, he pleads guilty, and he's released from jail, and lo and behold, another one of our 5 attorneys at random just got appointed to his 26th criminal trespass case. So we have already met him, we know what he's about, we know he's easy enough to get along with, and he doesn't really mind being where he is, and we're fairly certain, even before seeing a police report or anything, that he probably did what he's accused of. That's going to be a very quick and easy case for us, but most of them are not that easy.
All right, anybody got any questions right now? I want to throw up this theoretical case. Nacho, take the mask off so they can hear you on the camera better.
What's the difference between manslaughter and murder?
The difference is mental state. So murder is the stereotypical crime that they use in law school to teach us the different mental states. In Texas, there are 4 different mental states. There's intentional, which means I want for this, let's say for this pin to hit you. What's your name in the front?
Abigail.
Abigail?
Mm-hmm.
And what's your name behind?
Novaya.
Navarra?
Novaya.
Navaya. So if I throw this meaning to hit Abigail, I have intended to do that, okay? If second one is knowing mental state, meaning I'm doing this, I don't want to hurt Abigail, but I'm getting rid of the pin and I'm throwing it that way, and so I know it's gonna hit her. It's not really necessarily my goal, but I need to get it away from me, and well, it's good at places in. Then there's, beneath that, reckless, and that's where we're getting into manslaughter. There are 2 different types of manslaughter though. Reckless means I don't really care where it goes and I just kind of toss it. I throw it and I know that there's a good chance it's gonna hit Abigail, or it might hit, sorry, I already forgot your name.
Novaya.
Navaya. Or it might hit Navaya. but it's going to hit somebody. There's a good chance, and it happens to hit Abigail. So I've recklessly, not manslaughtered her, thankfully, recklessly assaulted her at that point. The lowest is negligence, which in criminal law, there's often not much of a split between reckless and criminally negligent, but with criminally negligent, it just means maybe you didn't know, like maybe you shouldn't have known to that high a degree I'm doing something and it's gonna hit them, but maybe the best example is with children. You leave children alone, well, you might not know that they're going to slice their arm open, but guess what? When children are alone, they sometimes do things that slices somebody's arm open. And so you may be responsible for that as the parent or the person that was supposed to be watching them if they hurt themselves. So murder is intentional or knowing, typically. I'm trying to kill someone. Manslaughter, and there's, you can have reckless or negligent manslaughter, but then manslaughter is going to be there's a big risk and you just kind of ignore the risk. So you throw a watermelon off a bridge without looking to see if cars are coming. If it hits a car and that car spins off and the person in it dies, that's going to be manslaughter.
So, involuntary.
What's that?
Involuntary manslaughter. What is involuntary manslaughter?
So the word involuntary in there is just saying you're not trying to do it. So it's not. If you're wondering if there's a distinction between voluntary and involuntary manslaughter, there's not.
All right, anyone else want to throw out a theoretical question? We have about 9 minutes left.
Here's a good one that someone had asked. What's the easiest way for you to figure out if someone is lying? I have 3 children, and this is just as relevant, if not more so, to my home life as it is my work life. There are lots of different ways to know. Body mannerisms are a pretty big portion of that, just to tell if someone, humans want to tell the truth. That's a fundamental thing about our nature. It's difficult for us physically to not tell the truth. Our body just rejects it. It doesn't like something that's not aligned with what we know is true inside of us. So watching their body mannerisms to see if they're fidgeting or doing things that are abnormal is a big part. But when you're asking the question, when you're talking to them, to me, the best way is you are illustrating what you believe to be as true. You're assuming things that you think they think are untrue, the things that they're going to push back against. And I guess here's an example. Abigail, that pen in front of you that you've been writing with, that pen is black, isn't it? No, right there. Yeah, that pen's black, right?
No.
Yeah,
No.
it is. So when you were writing with that the other day, what color was the ink?
Black.
Yeah, so you're assuming something is true in the way that you're talking with them and questioning with them that you know they're going to give pushback on, and then you just kind of monitor how they do that. If they can keep consistent with what you believe to be a lie and not jump onto your train of what you're trying to lead them to, then internally they probably at least believe that they're telling the truth. Every expert that I have ever seen of any kind, no matter how many psychology PhDs they have or polygraph machines that they have all told me, you can never tell whether someone is telling the truth or not. At the best, you can tell whether they believe they're telling the truth or not. So you can tell if they're being internally consistent.
So another way to think of this, guys, is let's say I have some mental health problems and I kill one of you. Not going to, but let's just say theoretically that's the scenario. But in my mind, I honestly believe I'm not killing you. I'm releasing you from the prison of this fleshy world.
Yep.
What's the difference? The difference is I'm still doing the act, but mentally, am I doing what I think I'm doing? Am I doing what I actually think, what I'm actually doing? No, like my brain is not there, and that's going to control some of the aspects of how, if you've heard any sort of cases like, was it innocent by reason of mental defect or insanity? Is that the?
Not guilty by reason of insanity.
Okay, not guilty by reason of insanity. Okay, so someone who's legitimately has a mental disorder and they hurt somebody, they kill somebody, and yet they may not go to prison possibly, but there's a step that they could send them to a mental health facility, right? Even if they don't convict them?
I was gonna
sorry.
jump into that if you want to.
Oh yeah, go for it.
Cool. So, sorry, I think that we're going to swap Hope in our office for Tammy for the next period. Is that okay with you?
Yeah, that's fine.
Cool. So, are you the right kind of crazy? There are multiple kinds of mental health defects. All are lumped, and I hope it's not in an insensitive way, because it's just an easy shorthand in the criminal world. All lumped in the basket of crazy, but in the criminal justice context, there are two parts that we kind of pick out, and those are the parts that can be relevant to the criminal justice system. Obviously, every type of mental health defect is relevant to my work as I'm talking to my clients and to try and interact with them and everything. I don't know if y'all have had it explained to you, but there's a huge intersection between mental health issues and the criminal justice system. The largest supplier of mental health services in our county is the McLennan County Jail. And that's insane. And that wasn't meant to be a pun. But if we're picking two of those things out in there, you've got competency and sanity. And what Mr. Menifee just mentioned is sanity, which means whether you knew at the time what you were doing essentially was wrong. So whether you kind of are seeing the things in front of you and are seeing, well, this is the pathway that's right, this is the pathway that's wrong, and you're choosing to go the pathway that's wrong. If you are not guilty by reason of insanity, you have committed the acts constituting a crime, but you can't be sent to prison at that point because you didn't know that what you were doing was wrong. Instead, most of the time, you'll be sent to an institutional mental health treatment program for up to the maximum punishment that you would have had in prison. So that can be for life. And that is a serious and daunting possibility. I have a client right now that he comes up every year to see, hey, are you still that kind of crazy right now? Are you dangerous, essentially, is what they're trying to determine. And every year so far, for the last 4 or 5 years, it's been, yes, you're gonna be there for another however many years. The other side is competency. Competency means, well, not back when you committed the alleged acts, or allegedly committed the acts that you're being accused of, but now, do you understand what's going on, and can you talk with your lawyer and answer questions and give facts? Can you get on the witness stand and form a cohesive sentence to say what it is that you think was happening? Can you make decisions right now, essentially? And if that's the case, you're sent also to, like on the other way, you're sent to a mental health facility, but that is only so that they can try to get you on medications or get you psychosocial services in some way so that you can be prosecuted. Eventually, if you're in that system, they have to just dismiss the case if it's clear that you're incompetent and you're not likely to regain competency. So like you're not a functioning human that should be put to trial. Then they may have to dismiss that case and try to have you committed civilly through a different process.
Okay, so guys, we're gonna, you have one quick question. One quick question, then we need to wrap it up.
So let's just say, you know the Veterans Hospital on New Road?
Yeah.
Let's say a patient of them runs out to the road and jumps in front of moving cars. Like, is that the driver's fault or is that the patient's fault?
So it may be nobody's fault.
Okay.
If someone is committing those acts, they already pretty clearly have some mental health thing going on, right? But then it's going to come down to what does the psychologist say as far as what they were experiencing, were they meaning to do it, did they know it was wrong, that kind of thing.
Okay, guys, give Mr. King a round of applause. Tell him to leave.